All rise. This Court of Appeals is now in session. The Honorable Jennifer Hensel presiding.
Good morning. Thank you. Please be seated. The first matter to come before us this morning is State of Ohio versus Ritzi Franchi. Yes. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning and keep you apprised of the passage of time. We've read the briefs and we are ready to see when you are.
Thank you, Your Honor. May it please the Court, Richard Cassay representing the state in this state appeal. The issue, simply stated, is what is the result when the state or the agents of the state innocently, I'm going to use the word innocently, but it could be inadvertent, innocently destroy evidence subsequent to a general demand for Brady material. Now, the trial court had this situation because in Mr. Franchi's case, on August 18th of 2014, the officer deployed her dash cam and audio recording device when she stopped Mr. Franchi's car. Then that situation led to the discovery of cocaine inside the car. Again, that occurred on August 18th. On September, and Mr. Franchi was later indicted for F5 possession of cocaine. So then on September 18th, there is a discovery demand, not specifically for the dash cam, but a general request for any exculpatory or potentially exculpatory evidence. A couple days later, the Akron police, per their normal procedure, although in this case the procedure was a bit unusual, and I'll get to that in a second, erased that particular dash cam. So the dash cam tape was no longer available. Now, why was this particular incident erased? Apparently the Akron police cruisers, at least the ones that are equipped with dash cams, each cruiser has 2 hard drives. One is in the cruiser and one is in storage. When one hard drive fills up, and I can't tell you what the capacity in megabytes or gigabytes or anything else, what the capacity of that cam is, but once it is filled up, it's taken out of the cruiser, and the other the other hard drive that is dedicated to that cruiser is taken out of storage, everything on it is erased, and that drive is put back into the cruiser. Now, Judge McKinney examined the logs of these cams, and in this particular case, there are 2, drive 2 and drive 1. Drive 2 had recorded the stop. That filled up, and then drive 1 was put in the cruiser, and it was about a month before that particular hard drive was filled up. It was taken out on September 23rd, subsequent to the discovery request, and drive 2, which had the incident, was the contents were erased and the drive put back in the cruiser. Now, how fast these cams fill up is a function of the frequency with which the officer deploys the dash cam. Maybe the officer deploys it a lot, maybe the officer, it just depends. Judge McKinney found that normally 3 months would be the minimum time before one of these hard drives is filled up. In this case, it was a month, meaning that it was deployed much more frequently than usual. So faced with that situation and the prior ruling of Judge Davis, who had overruled the motion to dismiss, or motion to suppress, on the basis that Mr. Franchi had given consent to the search of his car. Judge McKinney, subsequent to a motion to dismiss filed by counsel, had this hearing and found out all this information about the dash cams, and he found no bad faith on part of the Akron police in erasing the dash cam hard drive too. Nevertheless, he relied on two cases, State versus Benton, which is a case from 2000, in turn relying on Columbus versus Forrest, which is a case from 1987. And the rule there is, in this situation where there's a discovery request and the state destroys the evidence innocently or no, then the burden shifts to the state to show that the evidence was not materially exculpatory. So the court, Judge McKinney, applied that rule, found that even though there was no bad faith on part of the Akron police, the burden shifted to the state to show that the dash cam was not exculpatory, meaning that did it show that Mr. Franchi gave consent or not? Of course, the state could not show that because we don't have the tape. So then he revisited the motion, the ruling on the motion to suppress, found that the state had not shown consent and dismissed the indictment. What, unfortunately, Judge McKinney did not do was apprise himself of a case from the Ohio Supreme Court in 2007, State versus Giesland. And Giesland had basically the same fact pattern, a stop, and then the innocent/inadvertent destruction of the tape, and we don't have the tape. Now, what Giesland did and what in the state's view applies here, it drew a distinction between materially exculpatory evidence and potentially exculpatory evidence. And that test is encapsulated by Giesland, saying that the video would not be used to challenge the substance of the allegations. In other words, you can't use that video to acquit the defendant. This applies in this case because, assuming we had the dash cam, it cannot be used to acquit Mr. Franchi, because the dash cam, there's no evidence that this dash cam had the ability to see inside his car. Nobody ever claimed that. So faced with that distinction, materially versus potentially, the defendant has to show bad faith on the part of the state or its agents. Bad faith basically equating to malice, really bad intent or motive. Judge McKinney had already found that there was no bad faith on the part of the Akron police in erasing the contents of hard drive 2. What he should have done was do what Giesland required and say that this tape was not materially exculpatory. Potentially, it dealt with a collateral matter. Now, I'm not here to denigrate the Fourth Amendment, but the validity of a stop is collateral to the substance of the charge, whether or not the elements of that crime were committed. So it's potentially exculpatory. In that situation, the defendant has to show bad faith on part of the police. Not being able to make that showing when there's no repercussions to the state of Ohio. Certainly there's no dismissal of the indictment. So basically that's this case in a nutshell. We have an innocent action on the part of the police, and we do not have that faith. The evidence was potentially exculpatory. That should have been the end of the matter.
As I understand it, there was no, I want to call it like a records retention policy, that's not really that, but there was no established policy.
There probably is, Your Honor, but none was introduced, and Judge McKinney made that observation. The testimony at the second hearing was that generally the Akron police are going to preserve these dash cams. In more serious cases, any use of force by an officer, I'm sure in any homicide, probably in more serious felonies, rapes, aggravated robbery, that sort of thing. For these low-level 5th-degree felonies, there's not a universal retention policy. Had there been, we would still have the hard drive. But I have no personal knowledge of what their retention policy is. I'm speculating based on what I think is common sense. Now, interestingly, and this is a little off the point, but Judge McKinney in the last couple sentences of his ruling said we're getting into the age of body cams on police officers, making the need for retention even more important or acute. Now, I think he was getting to the point, if the officer here had a body cam and leaned inside the car, if that body cam is functioning, it's going to show the cocaine. That would be materially exculpatory evidence. If that body cam tape were then lost, even in inadvertent or innocently, then we have a different situation. But that is not what we have here. We have a dash cam looking at the car. Mr. Franchi gets out of the car and words are spoken. Did he consent or not?
I guess I'm not quite sure your analogy with the body cam and the cocaine in the car.
Well, was there cocaine found in the car or not? He's charged with possession, and the testimony is that he possessed the cocaine because it was in his car. If a body cam would show that it was not there, then we have a different situation.
Well, in that situation, yeah, you're talking about prosecution of a police officer then, because he put the cocaine in there.
Potentially.
Is that really, are we really talking about exculpatory there? I mean, I guess I'm just having a hard time determining what's exculpatory, because here you're talking about consent or not consent.
Right.
And without consent, everything's thrown out.
No, that everything may be thrown out, but it has nothing to do with proof of the elements of the charge. That's what Giesland made very clear, I believe. Could this evidence have been used to acquit, not grant a motion to suppress? Those were the facts in Giesland. It was a stop. The evidence, the tape, would have been useful to prove the validity of the stop, just as it would have been in this case. Now, my discussion about body cams and cocaines in cars, like I said, really was not on point, and with hindsight, I probably should have kept my mouth shut. But Judge McKinney mentioned that.
Because I was trying to figure out, when that tape would be exculpatory or non-exculpatory. I guess maybe if an officer had the dash cam or a body cam, doesn't really matter what, but somebody right in front of the officer shot somebody or knifed them or something like that, and then after the fact, it's destroyed, and he says, well, we misplaced it or reported over it or whatever, and that's actual evidence whether he did or didn't do it.
Right. If the tape somehow showed commission of the crime that the state is alleging, then if it didn't show that.
Right, that's what I'm saying.
Yes.
He says the officer said he shot him right in front of him, and a tape that shows that he clearly did.
Right. Or somebody else shot him.
Or somebody else,
Right. But there is a distinction. Again, I'm not here to denigrate the Fourth Amendment, but in a sense, that those are collateral issues to primary guilt or innocence of the elements of the charge. This dash cam does not go to the elements of the charge of possession of cocaine. And if there are no further questions, I'll reserve whatever time I have left for rebuttal.
Thank you. About a minute.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Attorney Connie Hightower, and I represent the FLE, who's Ritzi Franchi in this case. This particular case, the state has said Primarily, it's a case having to do with whether or not the court applied the proper law on this, and that basically is what it is in a nutshell. And I say there's some things that we have to look at other than what the state is looking at. The first thing is that, as the state has said in their argument, the video was not destroyed subsequent to a demand, and I think that the state said that repeatedly, was destroyed subsequent to a demand. In this case, the demand was made on September 18, 2014. And in that demand, it was not a general demand, and in fact, we attached it to the brief as exhibit or appendix E. It was not a general demand. It specifically asked for recordings. That was in the first item. It also specifically asked for any other evidence which would be relevant to this case. And then finally, it had a catch-all which requested any other relevant evidence or any other evidence pursuant to Criminal Rule 16. So it was more than a general request. If you look at the timeline, much of what Mr. Cassay presented to the court as far as the testimony on the timeline and what happens to the tapes is accurate. The only difference is that after September 18th, the dash cam was taken out of this particular vehicle and put into, I guess, like a holding, like storage. So what would happen would there would be two videotapes, two dash cam videos, if you will. One would be in the car, and one would be on standby to be returned to the car. So each car rotated two different videotapes. In this particular case, the video that had Mr. Franchi's stop and arrest on it would have been in the vehicle when it occurred and would have still been in the vehicle after the discovery demand was made. That was removed from the vehicle after and put in, that was removed from the vehicle before and it was put in storage. So the second one was in the vehicle as of September 23rd. No new video was recorded on that returned videotape. So let me make sure I get my timeline right. On September 23rd, the original videotape that was in the vehicle was returned back to the vehicle. That would have been the one with Mr. Franchi's arrest. I hope this makes sense. Nothing new was recorded on that until October 5th, and this is the testimony from the sergeant. So with the demand being done on the 18th and with no new information on the 5th, even though new information was recorded on that on the 5th, there's no guarantee it actually recorded over the stop. It would depend on where on that videotape that stop was located. So once the state had the request on the 18th, they never followed through, did not, and it was testified both by the officer and both by the sergeant that neither one of them sought to have that videotape removed once they discovered it was not there.
Was there any evidence presented that would indicate that once that video was removed from the car that it was deleted, that the day that was on was deleted, stripped, and then put back in blank?
No, the testimony was that it was they never looked to pull that tape and did not look at it. The only time they went to find if the tape was available was a week before the suppression motion in November. Does that answer your question?
No. My question is, once they pull a video out of the car because it's full,
Yes.
do they wait and then delete it, or they delete it immediately?
They don't delete it at all. They take that same video, rewind it to square one, and then let new footage record over it. So it's never deleted, it's just recorded over with subsequent video when it's returned to the car. Does that make sense? So it's never, the police department never...
It doesn't make any sense, but I hear what you're saying.
Well, it's not my policy, Your Honor, but...
That's what I'm saying, I hear what you're saying, but, you know.
Okay, so with that, though, it was not... The destruction of the video would have happened based on that videotape being returned to the car and allowing further video from new occurrences after October 5th to at some point in time record over it. One of the things I want to point out is that Judge McKinney was very specific in his judgment entry that he went back and he reviewed the testimony, reviewed the transcripts which were from the November suppression hearing, and then he made a factual finding in his April journal entry. And that factual finding of fact said that the officer testified, the defendant testified, and there were conflicting testimony from the defendant and the officer. There was new information which had come out with the testimony of the sergeant. So at the time that the suppression hearing was held, the sergeant was not available to testify as to what happened to the video cam. The defendant had made the request for the video cam from the state and had not received it, inquired about it at the suppression hearing, and then subsequently filed a motion to dismiss because they still had not had this information, and the officer could not speak to what occurred with it. So at the second hearing, Judge McKinney held it so that he can ascertain this information as to what occurred with the dash cam, and then revisit it, which I think under Criminal Rule 16 and under Civil Rule 54, Judge Davis's order was not a final appealable order, and I think that that judge has a right to review a prior finding and draw a conclusion. So the state has not argued abuse of discretion, and Judge McKinney, I believe, used his discretion, was able to look at a non-final appealable order, make a determination now that there's this newly acquired information to what happened, and make a determination that consent was not granted. So
I guess I'm still just a little confused because they had the suppression hearing with the one judge,
yes.
and then a motion to dismiss for a violation of due process rights was filed in regard to the destruction of the video recording.
Correct.
And then the new judge revisited basically credibility findings of the prior judge, didn't he?
Well, Your Honor, if you look at the findings of Judge Davis, it's actually pretty interesting because Judge Davis goes through all of the testimony and then in the end says, I've got to make a determination based on the totality of circumstances. And I don't think it was just a credibility determination. She found who she felt was more credible as to what occurred, the officer or the defendant, because the defendant did testify, and said, based on the totality of what I heard in the hearing, here is my determination. The totality of circumstances from what she heard in the hearing, and the reason why a credibility determination had to be made was because there was no video. And that video had been requested from the state and not provided repeatedly prior to this. So the first time the defendant was aware that in fact the officer believed there was a video and did not request it until a week before was at that suppression hearing. So I believe, since Judge Davis said, based on the totality of circumstances and there was new information adding to that totality, that it was in Judge McKinney's discretion to now apply that new information to those facts.
But at the original suppression hearing, as you just said, there wasn't the videotape.
I'm sorry?
There wasn't the video recording at the original suppression. I'm sorry, I had a sore throat, so it's hard. There wasn't the original video, the video recording wasn't at the original suppression hearing, just like you said.
Well, correct, but prior to that, the defense was under the impression, and it was at pre-trials from the state, that there was no video, that it wasn't recorded. And so it wasn't until that hearing that they realized that there actually was a recording that actually existed.
And I can't remember, did they ask for continuance?
The state?
No, the defense.
No, the defense did not ask for continuance. The defense did request, and again, it's not in that suppression hearing, but this is why there was a subsequent hearing held to ascertain what happened to that dash cam as a part of that suppression.
I guess I'm just wondering why it could have all been resolved in the first hearing.
Because at the time, that officer had no answers as to what was on the dash cam.
Well, we'll look at the record.
Okay, I'm sorry.
That's okay, you're not doing anything wrong, I'm just trying to figure it all out.
Backing up just a moment, Judge McKinney did not find bad faith on behalf of.
Correct.
So the argument about the timing of the request and then I think everyone agrees, the request comes in and then a relatively long time passes and the tape is destroyed. So if there's no finding of bad faith, then the argument that's left is whether or not it's potentially exculpatory or materially exculpatory. Is it not, or am I leaping forward?
Well, I believe it is, Your Honor, except there's one piece that, and that's why I said I don't think it's as simple in a nutshell. I think there's one piece that we're not looking at here. Okay. And that one piece is that the trial court has the ability to determine the facts in this case and the facts of which they want to rely upon prior to making that decision. And so I don't disagree with that argument, and I'll address why we think it's material. But the fact that Judge McKinney made these factual findings and the state isn't disturbing the fact that these factual findings were made, they're just looking at the law that he used to apply. I think we have to look at Judge McKinney's totality of the circumstances and what he took into consideration. So there's two different things. There's the suppression and whether or not the suppression should be dismissed,
Yeah.
and whether or not the tape is exculpable. I think those are two different issues. So to answer your question without addressing whether the suppression should have been dismissed, I don't disagree with that argument, but I believe that what the judge was saying, and essentially what the testimony from the first suppression hearing shows, is that it is material. The defendant said in the first suppression hearing, I don't know what she took out of that car. That's material as to whether or not that video would show if she in fact removed something from the car. The officer also testified that when she took whatever she took out of the car, she went in front of her vehicle, which would be what was recorded on the dash cam, so you would have been able to see if in fact the officer did take drugs out of the car, if in fact she did test those drugs there on the dash cam. I believe that that video is exculpable, and it's distinguishable from Giesland in the fact that Giesland had a partially recorded video that did show some things and didn't record other things that was inadvertently destroyed, and I think the time frame was either 24 hours or 3 days after the request or something to that nature. It wasn't weeks like ours was. But there was some information available in Giesland on that video. It just wasn't all the information. And in that case, the court had held that they didn't believe that that information that was not shown on there would be exculpable. In this case, the entire video is missing, and the act of the officer removing what she says were drugs, in which the defendant testifies himself at the suppression hearing, he doesn't know what she took out of the car. I think that is material, and it does go directly to exculpability. And so I guess this case asks the question, I know that the state was talking about police and body cams, but I think it begs the question of, if the state is the only one in possession of a video, and the defendant uses the proper mechanisms to request that video, and does not receive it, then how is that not problematic? The defendant should be able to have access to that.
What about back in the day when there were no dash cams? This would have been just credibility. It would have been straight credibility.
Correct.
And there was no dash cam available to either side in this
Correct.
case, and there was finding of no bad faith at all. So really, it's his word against her word.
Well, it would not be.
Well, I mean, back in the day.
Yes,
there
back
were
in
no
the
dash
day.
cams. And we
Correct.
just had to go by what he said, what she said.
Right.
Okay? And in this case, there is no dash cam, so it can't be used for the state's benefit. It also can't be used for the defense benefit, right?
But Your Honor,
So-
there was dash cam, and I think that's the difference.
But it wasn't available to anybody, and there was no bad faith. It
It was-
disappeared, according to Judge McCann.
I'm sorry, it was available to the police, but the police did not retain it even after the request. So I understand what you're saying about back in the day, and I understand if this was a case where it was a car not equipped with an IVS system, but it was equipped, it was recorded, it was not pulled when the defendant made the request, and there was never an attempt to pull it until right before the suppression hearing. So I think that there's a difference there. I think I have, about 1 minute?
A minute and a half.
Okay, thank you. So I think there are some differences, and I understand that it would be a credibility issue, and I understand it would be between the officer and the defendant. And, I can only say in recent times, maybe the last few years, where we have had dash cams and we have had body cams, there has been credibility questions between what the defendant has said versus what the officer has said, and it has clarified, sometimes in favor of the defendant, what occurred. Mr. Franchi testified that he believes that if there was a dash cam video, it would show his version of the story, and he testified to that at the suppression hearing. In closing, I think that we should be looking at the two different things. I think we should look at whether or not the state raised an issue of abuse of discretion, which was this trial court's findings of fact. And this trial court's findings of fact are undisturbed because no abuse of discretion standard was made. And so it just is whether or not, in dismissing this case, the trial court used the applicable standard. I believe that the standard was applicable. I believe that it was in the trial court's discretion to have made the dismissal, that our case is distinguishable from Giesland, and that if we do have to look at material culpability versus materially exculpable versus potentially exculpable, it's materially exculpable, especially when an officer would be shown removing contraband from a vehicle, testing contraband on that vehicle, and verifying whether or not it was actually taken out of the car and something in possession. This is a possession charge. The officer didn't just testify as high crimes. The sergeant said specifically that if an officer thinks a video is of evidentiary value, they can have the video pulled. Officer Tassone agreed that it was evidence in this case and did not have it pulled, and we think that that violates his due process rights.
Thank you.
Thank you, may it please the court. You know, obviously, this case is not about Judge McKinney's discretion. He either follows the applicable law or he does not. He has no discretion to ignore the applicable law. And unfortunately, he did so in this case, unintentionally, I'm sure. There's no doubt the state, or the Akron police, again, innocently dash inadvertently destroyed this tape. It was, now to try to answer a question, I think from Judge Schaefer, the hard drive wasn't taken out in this particular incident, singled out. The whole hard drive goes in storage until the hard drive in the computer fills up. When that occurs, my understanding of the testimony is the hard drive in storage is taken out, the information deleted, and the hard drive put in the cruiser. So it makes no difference that it wasn't until October 5th that hard drive 2 again recorded an incident on the dash cam. Because when it's put back, what was there before is gone. And Judge McKinney found no bad faith. Now, I don't know if counsel is trying to argue that
And
there was
counsel,
bad
I
faith.
apologize, but I need to let you know that you've reached the end of your allotted time today. But I very much appreciate your presentation, both of you. The court will take the matter under advisement and issue a written decision as you know both sides.
Okay, thank you.